Well, the next step in our felony defense series, we want to talk about the plea and arraignment. So this is the first real court appearance that gets things really started. And it gets kind of confusing. When you get arrested, if they hold you, they call that the first appearance where you're in front of the judge, but nothing really happens. Your real first court date is the plea and arraignment. And that's really what gets everything started, gets everything going. So in a nutshell, it's a pretty basic proceeding. All that you're going to do is enter a plea, and we always enter a plea of not guilty, all right? And so again, I don't care if you did it, I don't care if there's video evidence showing that you did it, we're going to plead not guilty at first. And because if we just walk in and plead guilty, you're going to prison, so we're not doing that. So if we have to go to court, then you're going to be there. They're going to give you a time. It's almost always 9 a.m. And you're going to be in there with probably 200 other people. But they'll call our name. We'll make sure that we put on record that we represent you. And then we'll start the scheduling process after we've entered a plea of not guilty. So if it's one of those courts where the judge makes you go, you're only going to be in front of the judge for about 30 seconds, and really not much of anything is going to happen. Now, because of that, a lot of judges will let us do a paper filing. It's called a waiver of arraignment. We really like that because it saves you a trip, saves us a trip. You know, there's no point in taking off work just to wait around for however long it takes to get called and then be in front of the judge for 30 seconds to say not guilty. But some judges just won't allow that. Other judges won't allow it for certain charges. So anytime we're dealing with a felony case and you have a court date, the default is you have to be there unless we tell you that you don't. And really the plea and arraignment is really the only one we can avoid. And if we can do a waiver, we'll let you know. But other than that, you're going to have to make arrangements to be there in court. So the next thing that's going to happen at the plea and arraignment is the court's going to start scheduling the next steps. What most courts do is they're just going to schedule a pretrial hearing. And what most judges will do, they just set one of these pretrials about every 6 to 8 weeks or so. And it's going to proceed like that. We'll go back for a pretrial. The judge will be, all right, where are we? They'll want to know what's going on with discovery. Have we been negotiating with the prosecutor? We give the court an update, and then we schedule another pretrial. And we just keep kind of going in that sequence for a while. And then at some point, the judge is going to say, all right, this has been going on long enough. We got speedy trial, where this has to be brought to trial in a year. So we either need to get a plea offer or get a trial schedule. And so that's kind of the process. And the reason that they have those pre-trials is eventually we're probably going to have some motions we're going to file saying if there's anything to have an argument over, we're going to hear it at those days. But whenever you hear a pre-trial date, keep in mind, it's you and a couple of hundred other people. And so especially over in White County, they're really notorious about this. They'll schedule 200 people for 9 a.m. and then they'll just get going kind of slow. And then whenever they feel like leaving for lunch, they'll just stop everything at 11:30, even though there's still 60 people, and just tell them to come back at 1. Well, there's 200 other people scheduled at 1, and then they're just all in there, and it's just kind of a cluster to get out. Once we go into those pretrial hearings, unless we have a big motion, again, not much is going to happen. But the courts are very old school of, we are setting court dates, you must come. And again, they don't care anything about your work schedule, about your kid's school schedule. They don't care how inconvenient this is for you. You're going to have to come. And unfortunately, now that we're outside of COVID, most judges, they don't do Zoom unless it's an exceptional circumstance. So the default, if you ask, can I attend by Zoom? The default is no. Sometimes they'll make that accommodation. There's only a couple of judges that are really using Zoom really well. But we're going to do that plea and arraignment. We're going to plead not guilty. That's going to get the schedule set. And then we're going to get to work with our FOIA and discovery, and then start getting into our standard motions and see how best we're going to defend this case. But that's how the plea and arraignment works. Thanks.